Court does call the case. The people of the state of Michigan versus Sonny M. McLean.
In a tense Michigan courtroom, the air feels heavy with accusation and disbelief. Two names echo across the chamber, Sonny and Milan Cross. What begins as a simple public altercation spirals into claims of threats, weapons, and fear. Judge Simpson presides, steady but unflinching, as he prepares to untangle a web of contradictions. Every movement in this courtroom matters. One wrong word could shift how guilt is perceived. This case isn't about a murder or robbery. It's about perception, credibility, and who the court chooses to believe. The defense paints a story of harassment and intimidation, while the state argues that fear was weaponized. Watch closely as the testimonies unfold. You'll see not just what's said, but what's avoided. Who do you believe when everyone claims to be the victim?
Cross-examination.
Which part of water, but it's not that far, maybe past the doors a little bit, where you come in, past the doors a little bit, I said earlier about 50 feet from where I was sitting at.
Okay, for where you're sitting.
And it's a big, like, field, right, it's a lot of up through the field, and it's the water.
So, but you said you got halfway to the water.
Midway, she saw me, I mean, I can't say exactly halfway or midway, but she saw me and came up from her pavilion. Everybody's a witness, I had witnesses that saw it, so.
So you're about 25 feet away from the.
I don't know how many feet I was, sir.
All right.
You don't. Never mind. Never.
So you said that she followed you back. Got midway to the porta potty.
She followed me all the way to the porta potty and back.
All right. So did you actually go into the porta potty?
Oh, yeah, she went in the other one.
Did you see her going to the?
Yeah.
Okay, but you went into the porta potty first.
I went to the porta potty first. The reason I knew she was in the porta potty because we came out about the same time out of the porta potty, and that's when she followed me back over there by the tree.
Oh, all right. So she followed you, and this is where she told you that she had guns.
Everybody heard her say that, the witnesses and everybody.
But this is where she said.
She kept saying, we got guns the whole time, but then when we got back by the tree, she said it about 3 or 4 more times.
Here's the bombshell. Threats of guns, whether true or not, carry legal weight. Even mentioning a firearm repeatedly in a heated argument can be interpreted as menacing or assault by threat under Michigan law. The prosecution leans on this moment heavily because intent to intimidate can be as serious as possessing the weapon itself. Judge Simpson's tone sharpens. He knows the gravity of this claim. If the witness's story holds, it implies clear provocation. But the defense will soon argue, if everyone heard the threats, where's the consistency in testimony? Contradictions already appear. Ask yourself, is repeating, "We got guns" 4 times a show of power or fear? The courtroom will dissect those words like evidence itself.
Okay, so I need you to understand the question I'm asking. I'm not asking you whether or not everybody heard it. I'm asking you this. When she said, when you left, she followed you. She approached you and said she had a gun.
Yes.
Is that correct?
Yes.
Okay. At this point, you asked her if she wanted to fight, right?
Yes, I did.
All right. Now, all the way up to this point, she's not complaining about you being under the pavilion.
Yes.
She is.
Yes.
But you hadn't been under the pavilion, had you?
She came over there and said she don't care who at the park, ain't nobody coming under that pavilion with her grandkids, me or nobody else.
But you hadn't been under.
Because I don't go under there. I don't like sitting over there. But if I wanted to go over there, it would have been a problem because it was a problem in the past with people sitting under there with Mrs. Simon.
So I want you to understand the question I asked. Okay. You hadn't been under the pavilion at this point.
Not at that time, no.
And tried to go under.
Not at that
I
time, no.
told you were.
No.
All right. So she said that she had guns. This wasn't about you being there. You wasn't.
She said she had guns a threat towards me. Because she didn't say it to the lady that she didn't want under that pavilion. She told me she had a gun. And when she said it.
And this is all about keeping people out.
When her grandkids is at the park.
This whole conversation was about keeping people out of the building. Yes,
Yes, while her grandkids is at the park.
you hadn't gone under the pavilion.
No, I didn't,
You had
sir.
tried to go under the pavilion.
I already told you no, sir.
You went, I don't care what you were told. I asked you a question, you answered that question. You hadn't told her that you were going.
No, sir.
You hadn't tried it.
No, sir.
So when she came out and said she had guns, your response was to ask her if she wanted to fight.
Yeah, I sure did. Because she shouldn't have followed me, put her name off. She was a threat. That's why I asked her if she wanted to follow.
But at this point, she just approached you and told you she had guns. She had to put out actually.
She was just on the gun at first, and then she hollered again when she pulled the knife out.
But you had already asked her before she pulled the knife out if she wanted to fight. Is
When
that
she
right?
followed me to the porta potty.
Now the tension spikes. This isn't just verbal sparring. This is escalation under scrutiny. The judge zeroes in on the timing. Asking someone, "Do you want to fight?" before a weapon appears, raises the question of who's provoking whom. In criminal law, sequence determines blame. If the verbal challenge came first, the defense's claim of self-defense weakens dramatically. Judge Simpson's measured phrasing is surgical. He's testing consistency under oath. You'll notice he keeps cutting off long explanations with "just answer the question." That's not impatience, it's strategy. Courtroom fact-finding isn't storytelling, it's dissection. Each contradiction becomes a crack in credibility. Would you call out someone holding a weapon, or would instinct tell you to walk away? The law expects restraint. Emotion rarely delivers it.
Right, but she didn't pull out any knife.
Not the first time, not the way to the porta potty. She pulled the knife out on the way back to the from the porta potty.
So I'm asking you at what point you told her, asked her if she wanted to fight.
When the first time that she
All right,
followed me.
listen to the question. Was this before or after she pulled the knife?
I asked her, did she want to fight before she pulled the knife out? So she came over there and threatened me.
All right, all right, all right.
What was her threat to you?
Her threat was, the threat on Judge Simpson is that she's talking about the white lady could get her ass kicked while she's following me to the porta potty, and I could get my butt kicked too. So that's what.
Well,
I
when
asked her,
did
she
that
want to
happen?
fight?
Because you didn't say that before.
That's why I asked her, did she want to fight? I wasn't trying to go into that. I was just trying to answer the basic questions, Your Honor. But. she
Well,
wasn't
but you're
threatening.
adding stuff.
No, I'm not, Your Honor.
Yes,
No,
you
I'm
are.
not. No, I'm not.
Because that's not what you told me. Go ahead, Mr. Brown.
So. When you asked her if she wanted to fight, her response was, "Me and my daughter want to beat your ass."
Yes, sir.
All right. And then what did she do after that?
Walked back over there and gave the daughter, while we was coming back, her and her daughter met up and tried to jump me. We told the police that.
Didn't you tell her that, didn't you tell us just now that after she said, "Me and my daughter want to beat your ass," that she then pulled out
She did.
the knife?
She did. Once we got back, once she followed me from the porta potty, she walked over there and pulled her knife out.
All right, so I have to be clear now, because I wasn't there. I need you to,
And I'm trying to make it the best as clear to you as I can.
let's work together. So. She comes out of court. Follows you, right?
Back to where I was sitting at.
All the way back to where you sit.
Yes.
So did you sit down?
No, I didn't.
Okay, so before you sat down, she says to you, she and all her friends have guns, right?
Yes, sir. She was hollering, "We got guns, we got guns." Everybody over there.
And that's where you were sitting in that area. Said, you asked her if she wanted to fight.
I told her to put her gun down and we could fight. If you
Put
got
her
it.
down. Okay.
If you got
Put
it.
her gun down?
But we was going back and forth. There was a whole bunch of stuff said, Your Honor. That's why I kept asking her, did she want to fight? Because she kept.
Okay, so hold on a second. I'm sorry, Mr. Brown. You said that you told her to put her gun down and then that's when
It was
you
always
asked
being
her.
sarcastic, like, if you really got a gun, then put it down and let's fight, since you keep approaching me. I was really being sarcastic
So-
when I said that to her.
Oh, okay, go ahead, Mr. Brown.
It was a lot of words said between me and her during the argument. So we both were saying things. But she kept hollering, we got guns, we got guns.
All right, so let me ask you, did you see her with a gun?
I seen her with a knife.
How with a gun?
I didn't see her with no gun, but I did see a knife.
Never saw a gun.
Never saw a gun, but I seen a knife.
She ever reached like she had?
She reached for the knife.
Did she ever reach like she had?
Yeah, she went back here like, we got guns, we got guns.
Oh, so she reached like she had one.
And then came out with the knife.
She had one tough way back there.
And came out with the knife, yes, sir.
But she reached back there, thought maybe she reached for her.
I didn't know what she was reaching for, sir.
Well, she talked about having guns.
But I didn't know what she was reaching for,
She
sir.
talked about having guns.
I didn't know what she was reaching for.
So you have to listen to the question that I asked and then answer that question. Don't just say what you want to say. You want to answer the question. So when she said, we got guns, and then she reached back like this, thought she was reaching for guns.
I didn't know what she was reaching for, sir.
What did you think she?
I don't know.
You don't know what you thought.
This is where everything starts to unravel. The witness claims the defendant reached back like this, implying a threat, but admits she didn't know what the motion meant. That uncertainty undercuts her entire testimony. In court, perception without evidence is dangerous. A reach can look like aggression or self-defense depending on who's watching. Notice how Judge Simpson presses on the missing details. You don't know what you thought. That's not sarcasm, it's legal precision. He's highlighting that emotional reactions don't prove danger. This is the turning point. The case shifts from concrete claims to conflicting memories. When your own words introduce doubt, the prosecution's case starts bleeding credibility. Could fear alone justify a reaction? Or does fear need proof to matter in court?
I know what I thought, but
So tell me what you thought you was reaching.
the gun like she said, that's what I thought.
Awesome. So, she didn't pull out a gun, she pulled out a knife, so she pulled out from the back here, right?
Somewhere along here,
All right. Now, did you say earlier that she had pulled out a knife?
she pulled the knife out of her pocket, somewhere over here. That's what I said.
But you said she reached back.
When she was hollering, we got the gun, she did that, then she went here and pulled the knife out of her pocket. That's what I said.
Okay. So she reached back, said she had guns, but instead of reaching, put some out. She then went into her pocket
And got the knife,
and got a knife. Okay,
and clicked it out.
so she reached in and she pulled the knife out.
Yes, she did.
Did she show you what she had?
Yes, she did. She pulled the knife out and noticed at me like she was about to stab me.
Now, was this a flicking action or did she open it?
No, she flipped it like flick, you know how you flick it open? And then came at me with it.
Yeah.
And the witnesses that attest to that too, because they see the whole thing.
And so you described this as a black, right?
The blade was black.
A black blade.
Yeah, it was black. The blade was black. And the handle had
Once again, show me, show the court, of course.
the blade's about that long, not the handle, just the blade.
Just great.
Just the blade part that she whipped out. It was a kind of a big knife, sir.
All right.
Big pocket knife.
Big pocket. And you said she was close to it.
Real close.
And you could reach out and touch her.
Well, she could have reached out and stabbed me. Yes, sir. Yes, sir.
So with this knife in her.
I'm good, go ahead.
Lunge.
Yes, she did.
Okay, so how did she, where was her knife?
In her hand, and she like this.
Oh, okay, so lunge and went like this.
Yep, and I stepped back.
Oh, right.
Yes, I was. I was able to step back, and that's when the other girl, Cherie, came from around.
So she lunged at you, she at the same time she stood her hand out in your direction, like.
Yes, she did.
Like she was gonna stab.
Yes, she did, sir.
And if you have, well, I want to thank you for your time.
How many times did you ask her did she want to fight?
Judge Simpson's patience wears thin, and so does the testimony. By this point, even he recognizes the circular logic. The witness admits to asking twice if the defendant wanted to fight, which raises an uncomfortable legal reality. Mutual aggression voids self-defense. When both parties contribute to escalation, the court must decide who became the true aggressor first. Simpson's tone is calm but cutting. He's signaling doubt. The more the witness repeats, "She followed me," the more it sounds like two people feeding the same fire. This is the midpoint of the case where truth feels elastic. Facts bend under ego and anger. The judge isn't just ruling, he's untangling psychology. Do you think both sides were provoking each other here, or is one truly innocent? Drop your thoughts below. This courtroom is just getting started.
Twice,
Okay,
after she approached me,
okay. When the mace came out, did you point it in her direction?
no, I didn't.
What'd you do with the mace?
I just took it off my purse and just had it in my hand, and I had my hand down beside my side like this. So I didn't point it at her, none of that. And my witness could attest to that as well. I did not try to spray her, I did not run up on her with the mace. I just unhooked it and put it down by my side.
Did the police see your mace?
Yeah, it was hooked on my thing right here.
Okay, did the police see it?
Yeah, I don't know.
Did you
They
give
didn't
it
say-
to them?
No, they didn't say anything about the mace.
Did you tell them you pulled mace?
Yeah. I told the officer I had to take a mace.
Well, no. Did you tell the officers that you pulled the mace or unhooked the mace in response to her?
I think I did. But I was explaining what happened to him, and I told him that when she walked up on me with the knife, that I had my mace.
Okay, can I just, yeah, go ahead there, because I get more.
All right, so you did speak to the police, right?
Yes, sir.
Okay, if I showed you the statement, where you spoke to the police, well, first, you're saying that you told the police that you had this, right?
You can see it was hanging on my purse right here.
Did you tell the police that you pulled it out?
Yeah.
Okay, you did?
I told him to defend myself.
So I'm gonna bring something. What you do is read over it, and I want you to point out, part where you mentioned to the police that you had. Can you do that one?
Yeah. I see it.
Well, thank you, I don't have.
I got a couple more. Did you 3 or 5 o'clock, whichever time you get down there, did you have anything to drink?
Here's where credibility takes another hit. The judge begins probing not the fight, but the state of mind. Alcohol or drug use can drastically impact a witness's reliability. Under Michigan law, voluntary intoxication doesn't excuse actions, but it can cloud perception. The witness first denies drinking, then admits to smoking weed during the altercation, a damaging admission. This matters legally because impaired judgment affects both credibility and self-defense claims. If someone's memory is blurred, their version of who lunged first becomes unreliable. Judge Simpson's tone stays calm, yet his direction is surgical. He's establishing whether the chaos was fueled by emotion or substance.
No, sir, I didn't start drinking until after I got to the park.
Okay. So between the time that you got to the park and the interaction that you had with the defendant, had you had anything to drink?
No, I didn't, no.
At all?
I don't think I started drinking right away, Ron. When I got.
Well, no. I'm not asking you what you think. What I'm saying is, do you know whether you had anything to drink?
Yeah, because once I got to the park, we had to wait for a girl to go to the store, and she took a long time, so I didn't have anything. She was bringing my beers back, so I didn't have anything to drink right then. But I was drinking at the park. Yes.
So you're telling me you were down at the park, you had nothing to drink at all?
That's not what I'm saying, Your Honor.
Oh, okay. So, well, let me rephrase that. That you were down at the park and prior to this entire altercation or whatever happened, you're telling me you had nothing to drink?
No, sir.
No, that's not what you're telling me, or no, you had nothing to drink?
No, I had nothing to drink.
Did you have anything to smoke?
I smoked some weed.
Okay, let's go there. How much weed did you have before you went down?
None. I didn't smoke the blunt till I got to the park.
Was that before or after the altercation?
It was during the altercation.
Oh, so you were smoking during the altercation?
Yes.
Okay. When did that happen?
Well, I'm trying to figure out what it was.
You tried to lay out, and I'm going to tell you, you've told me about 2 or 3 different things that you've laid out in terms of what happened there. But at some point, then you had this blunt.
Yes, ma'am.
At what point were you smoking the blunt?
I'm trying to understand your question, but.
Well, here's my question. When you say she lunged at you with a knife, did you have the blunt in your hand?
We didn't really get to smoke it, but I think we like smoke because the stuff started jumping off. So no, I didn't have the blunt in my hand when she lunged at me.
So at what point? Did you have the blunt in your hand when you were headed to the restroom the first
No.
time?
No, sir.
When you were headed away from the restroom, did you have it in your hand?
No, sir.
At the time that you say she pulled the knife, did you have it in your hand?
No, sir.
At the time that you're fighting back and forth with her, did you have it in your hand?
Well, I had the blunt when she followed the white lady back over there by me and said she couldn't sit under the pavilion. That's when I had the blunt before we started arguing.
And so, okay. So that's when you had it.
Yes, sir.
And then never had it in your hand again?
No, because the stuff jumped up.
The what?
Everything started happening. The stuff with the pavilion and everything just started happening.
So why did you ask her, do you want to fight?
This question slices through all the noise. The judge's inquiry isn't casual, it's a legal trap. Asking someone to fight can transform you from defender to aggressor. The law doesn't protect those who invite violence, even if they later face a weapon. Notice the tone. The witness stumbles, trying to justify the question as a reaction to being followed. But in law, provocation voids protection. By saying, "I turned around and asked if she wanted to fight," she inadvertently admits intent. This is where legal drama meets human ego. The courtroom falls quiet as Judge Simpson redefines the narrative. Suddenly, the victim might look like the instigator. So who crossed the line first? Was it fear speaking, or was it defiance? The law doesn't reward pride, it measures prudence.
Because when she followed me the first time to the pavilion, she came at me aggressive about not letting that lady sit under that pavilion and calling me all type of bees. So I turned around, I said, "Do you want to fight me or something? I mean, what? Why you keep following me?" That's why I asked her that. Because she came at me aggressive.
This knife that you say, based upon what you said, is about 6 to 7 inches. You also testified she's an arm's length away from you.
She was close.
Excuse me. But you said she was I watched you. You said she's an arm's length away.
Yes.
And then you said she lunged at you.
Yes, she did.
And she didn't strike you with the knife.
Because I stepped back.
How long were you able to observe that knife in her hand?
This moment is pure courtroom chess. The judge isn't asking for story. He's testing temporal precision. The witness says she saw the knife for a few minutes, then changes it to a few seconds. That flip is fatal. In a case centered around a weapon, inconsistencies about timing dismantle the prosecution's narrative. If someone truly faced a knife, their reaction time would be instant, their description vivid. Hesitation signals exaggeration. Judge Simpson's restraint is deliberate. He's letting the witness self-contradict, a quiet strategy used by experienced judges to expose unreliable testimony without confrontation. This testimony shows the gap between perceived danger and provable fact. Without a recovered weapon, this entire claim teeters on storytelling. Would you remember exactly how long someone pointed a knife at you, or would panic blur the details? The answer decides guilt or freedom.
She had it in her hand for a little few minutes. It was long enough for everybody to see it. She still had it in her hand after she lunged at me with it.
Before she lunged at you, how long were you able to see that she had it in her hand?
Long enough for her to go in her pocket.
No, not long enough. Like, how long were you able to see that knife in her hand before she lunged at you?
A few minutes.
A few minutes.
A few minutes.
So she's got a knife in her hand.
And she pulled it out and lunged at me.
Hold it. She's got a knife in her hand and you're arm's length away from her for a few minutes?
Yes, but everything's happening so fast.
Not what I'm saying. What you testified to is that she pulled out the knife and that she lunged at you.
Yes, sir.
But now what you're telling me, please correct me if I'm wrong, so she pulls out the knife, it's a couple minutes, and then she lunges at you.
She pulled the knife out and lunged at me. Like,
Okay, ma'am, hold on, Ms. Morgan. I just asked you how long did you see that knife in her hand before she lunged at you? And you told me a couple minutes.
well, I wasn't paying attention to the time you are. I see.
Okay, but Miss Morgan, it's either a couple minutes or it's immediate.
It could have been a couple seconds.
Okay, you don't know.
I don't know.
All right, any further questions? Okay, good, go for it.
Ms. Morgan, can you describe again when Ms. McLean took the knife out for the first time? What did she do with it?
She pulled the knife out and clicked it back and lunged at me.
The click becomes the centerpiece, the sound that supposedly marked the threat. But with no physical knife recovered, this moment turns symbolic, the sound of danger without proof of danger. Judge Simpson's experience shows here he knows emotional testimony often amplifies small details to fill evidentiary gaps. The defense will argue that if police didn't find the knife, this story collapses. In legal terms, this is called reasonable doubt born of inconsistency. The judge doesn't accuse her of lying outright. He simply lets the missing evidence speak louder than her words. To the audience, this illustrates a core courtroom truth. Drama does not equal guilt. Theatrics can sway emotion but not verdicts. If the click never existed, the entire case changes tone from survival to embellishment.
Clicked it back?
No, open, you know how you click the knife open. You know how you click it open. And she pulled it out, clicked it open, and lunged at me.
Thank you. Counsel President.
Do the people have a motion?
Now, this is a very astute wise court.
I am.
Presided over probably thousands.
Easy, and that was just yesterday. Go ahead.
I will refer to the discretion of the court as to what should happen moving forward with this case.
Mr. Brown,
No,
briefly.
I don't think that the witness testified, but the court, of course, has a duty to look at credibility. We've got several different versions of what happened. Some quite contradictions and conflict. As we don't, it's going to be hard to do. That's
In this case, listen very closely to the testimony of Ms. Morgan and what was being told to me and why I was asking some of the follow-up questions is that the court believes, I heard different versions of what happened. I am also concerned because the crux of the felony charges is about the defendant purporting to have a knife, and certainly Ms. Morgan's response was the mace. The mace is not at all discussed in the police report. And Ms. Morgan is a bit unclear as to what she says she did with the mace, but that's not really the important issue. Their issue is was there a knife? Police do not recover a knife where there's no evidence that the police recovered a knife. I'm gonna just say at best, it is murky about supposedly having this knife and what then happened. There couldn't have been a couple of minutes. Well, first of all, it was an immediate lunge when she opened the knife. That was on just testimony before the court asked any questions. Then when asked how long she saw the knife, it was a couple of minutes. Then, quite frankly, when Ms. Morgan realized that doesn't work, she was then asked the question again, and then it was an immediate thing, and then it was clarified that it was some immediate thing. Frankly, from this court's perspective, I don't think there ever was a knife.
This is the hammer drop. After dissecting contradictions and missing evidence, Judge Simpson delivers his verdict with surgical clarity. I don't think there ever was a knife. That single line reframes 20 minutes of testimony as unreliable. Legally, this signals a decline of probable cause. Without physical proof or coherent accounts, a felony charge can't stand. Instead, the judge downgrades it to misdemeanor assault, a decision based on evidence, not emotion. What's remarkable is his restraint. He doesn't accuse anyone of lying. He simply states that facts didn't meet the legal threshold. This is the essence of judicial reasoning. Removing noise, finding signal. Would you have ruled the same way? Did the witness's confusion justify this outcome? The law demands certainty, and this case never had it.
And I don't think there was any response with Mace. I think what happened is these folks got into a dispute. They started arguing back and forth, and may have indeed, I believe, Ms. Morgan, to the extent that there were threats or an argument going back and forth, probably between the two of them about whatever. So the court is going to decline to bind the defendant over finding no probable cause on count one. I will send the case down on the misdemeanor of assault and or assault and battery. She has already pled not guilty to that charge. I'll set that for pretrial before Judge Barr.
October 9th at 10 a.m.
October 9th, 2024, 9 a.m. before Judge Barr.
Thank you.
No, the bond violations, I'm going to send that along with it to Judge Barr to address. Thank you. Huh? Okay, now, because we had this issue before. Yeah, I know. I set the rules. Ms. Morgan, you may get on the bus first. So you can leave and then you will take the second bus. Thank you. Court needs a brief break, so I'm going to stand in recess.
All right.
And just like that, Judge Simpson closes the case. The felony vanishes. What remains is a misdemeanor, proof that sometimes chaos doesn't equal crime. His ruling reflects legal precision. Without credible proof of a weapon, the harshest charge cannot stand. This case underscores a courtroom truth. Credibility is everything. Witnesses may feel wronged, but emotion doesn't substitute for evidence. The prosecutor's case crumbled under contradictions, while the judge upheld the principle of innocent until proven guilty. As the gavel falls, the message is clear. Passion without proof loses power. The law may be cold, but it is consistent. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns from Trial Truth.